Good evening, friends. Welcome to my channel, Judgment Day. The aim of the channel is to discuss various important judgments of Honorable Supreme Court and various High Courts on a daily basis. Today, we will discuss about an important case which was the judgment was given by Honorable High Court of Kerala. So this case is an interesting, and also most of us would like to say many of us have come across the same scenario on a daily basis. So let's look into the details of this case. The case is very interesting. This particular instance happened in a place called Kalamassery in Kerala. This Kalamassery is a municipality, and a person by name Mr. Pali Vadakkan is a famous director of Malayalam cinema. So he is the complainant. So that person, honorable gentleman, went to a shopping mall by name Lulu International Shopping Mall at Kalamassery, and he parked his car in the parking, and once he came back to pick his car after his shopping is done, the staff objected him and also asked him to pay the parking fee. So in fact he argued with them, saying that this parking is free. As I am a customer, this parking should be free for me. And in turn, there was an exchange of words between the staffers and also the gentleman, the complainant. So finally, Mr. Pali Vadakkan approached the High Court, arguing that the parking should be free as I am a customer, and it has been included in the bylaws provided by Municipality Act of Kerala. So in view of that, so Honorable Kerala High Court gone through the details of the various clauses provided under Kerala Municipality Act, and particularly the section 447 of Kerala Municipality Act, which says that the license was given under building license was given under 447 section, and the senior advocate S. Sri Kumar, appearing for the respondent, he submitted the details. And he argued that all the permissions which are required to operate the parking space was got through that. Interestingly, Kerala High Court ruled that that parking should be given as a free of without any cost. And while doing so, it has gone through an important judgment given by Honorable High Court of Gujarat on the same manner. So the High Court order of Gujarat states that the judgment was given in the year 2019, and Honorable Gujarat High Court ruled that malls and multiplexes should not collect parking fees, as they are under a statutory obligation to provide car parking space free. So this was the judgment. Interestingly, last year, Honorable High Court of Karnataka refused to entertain a plea seeking free car parking spaces in malls and multiplexes. So what it quoted was, somebody incurs a cost for maintaining the parking space at a cinema hall. How can it be for free? So these two are contradictory to each other. Interestingly, the Karnataka High Court has not given judgment. Instead, it rejected the application. So the judgment of Gujarat High Court holds good, and the High Court of Kerala stated as the parking charges should not be collected from the customers, as the mall or the shopping area is constructed in accordance with the municipality bylaws as stated in section 447 of Kerala Municipality Act. So the case title is Pali Vadakkan versus Lulu International Shopping Mall. So this is the case. Interestingly, as we have seen, or most of us have come across the daily scenario of the parking problem, and also the traffic. Most of our Indian cities are not planned cities, and park every day. The traffic is a huge menace on roads, and very importantly, and very basic and fundamental rule is the roads are provided, or roads are meant for traveling or for transportation purposes, not for parking. They should not be used as parking spaces. That is the thumb rule. So going by the thumb rule, it's the duty of commercial complex owners and also commercial complex establishments, authorities, the governing the commercial complexes should provide enough parking space exclusively for their customers. This is the fundamental rule. So while doing so, most of us might have come across these situations wherein many of your times our vehicles have been lifted away by enforcement authorities, by levying heavy fines. We need to go to that particular jurisdiction, the station or the parking lot. Then we need to pay the fine. Then we need to take care of our vehicle. While doing so, most of the times vehicle might have got damaged also. This is also the scenarios. So this instance shows that how courts are saviors for even the smallest of the smallest, something like basic fundamental problems of common man. So Honorable High Court has done a notable job in providing a relief for a common man's very fundamental issue, parking space. So it upheld the general, or what we can say, natural justice, by saying that it's the duty of the commercial complex owner to provide the basic amenities for their customers, exclusively for their customers. So this is the thing. Most of the times, many of us might have come across same scenarios, and we might have argued with the people, either maybe parking people or maybe law enforcing authorities relating to this. And this case is really appears as a very good judgment, and also a very good case to strengthen our stand. So this is all about this case, friends. So please, I request all of you to provide your valuable comments, opinions in the comment section below, and also I request all of you to subscribe and share my channel with all your friends, contacts, known people. So